So the legal aspects of probate real estate, there's some similarities across the country and differences. I'm always excited to meet an attorney in a different state than I operate in. I'm in California. Today we have Massachusetts attorney David Ceruolo. David, welcome to our call today.
Hi, how you doing, Bill?
Great. I know you're in Massachusetts. What part of Massachusetts are you in?
Well, I'm just north of Boston, in a city called Melrose. So we're about 10 minutes outside of Boston without traffic.
Yeah. I was thinking LA, 10 minutes without traffic, but 2 hours with traffic. And okay, good. So you're in the greater Boston area. And it sounds like, no, I know because my wife is from Boston, actually from Belmont to be specific.
Oh, Belmont. Okay, yeah.
So I detect you don't have a Southern California accent. So you're a native Bostonian?
I am. Why, you don't like cars?
Well,
You like to park the car?
Parking Harvard Yard.
In the yard?
So how'd you get into the practice of law, and specifically how'd you get into probate and related business?
So let's see. When I was I had this notion in college that I wanted to be a lawyer, and I stuck with it for all that time. I was admitted to the bar in 1997 in Massachusetts, admitted to the bar. And so from there, I started as a conveyancer. And when I did a lot of real estate, I did residential and commercial transactions. And I had a lot of older clients. And so what would happen is they'd come in and they'd say, hey, can you do my will for me? And I didn't want to just do the will for them. I wanted to learn, all the ins and outs of estate planning. And the gentleman that I was working for, the attorney I was working for at the time, was an accountant as well as an attorney. And so I learned the tax spin on things along with the legal spin, and I was able to do that. So that's kind of an evolution. It went from residential real estate to commercial transactions. And then what would happen is the older clients would pass away and I end up in the probate court, doing the probates for the families.
So I see you do probate law, you do estate planning, which is avoiding probate, and you do elder law, which I describe as when all that wasn't done right, then you get into elder law, right? What do you see? How do you describe elder law?
Elder law is a combination, like you say. It's a combination of estate planning, and sometimes you do find yourself in the probate court as well. But I guess there's a gamut. There's estate planning. If the person is still with us and they need assistance and they don't have their estate planning documents in place, then we do oftentimes end up in probate doing guardianships and conservatorships for them. So it all is related, and it all ties back a lot of times to real estate as well, too. So, and elder law also has a facet in it where we deal with Medicaid. So if a person's going into a nursing home, then, I'm not sure what they call Medicaid in California, but here they call it Mass Health. And the reason why Medicaid, the program is called Mass Health, is they're trying to avoid the confusion between Medicare and Medicaid.
Correct.
So they call it Mass Health in Massachusetts. I'm not sure what they call it in California.
Medi-Cal.
Medi-Cal.
So it's not confused with Medicare. You're exactly right. So your practice, and I think this is the thing I always recommend to the agents that I work with and the families. When you're looking for somebody to help you, you want somebody who's a specialist. So you really specialize in the probate and related fields. And then your real estate is kind of, I guess, is a function of that, or your estate planning is a function of that.
It just kind of all ties together. A lot of times with estates and elder law, the biggest asset a person has would be their home. And so you end up dealing with that, whether it's in the probate court, and then you deal with, of course, the contracts in Massachusetts if the house is going to be sold. So it all ties together. And I've been doing all of it since 98, 2000. So I've been doing it for a long time. Mass Health, Medicaid has evolved through that time as well, too. So I've seen that.
So what's a typical probate case cost the customer by the time they're done? If they're just probating, at least in my experience, 80-90% of the time, it's just there's one property that requires it to be probated. So they have to go through the process. And in California, there's a statutory limit, can't charge more than, but can charge less than. What's the range of fees on a standard probate case in Massachusetts?
So there's one of two ways that a party can file a probate in Massachusetts when somebody passes away. If everybody the way I kind of distinguish them is if everybody gets along, right? The family's getting along, there's no objections, there's no problems inside the family, then we can file a probate. informally. And when we do that, the informal costs usually range around $3,000, $5,000, depending on what's needed. If there's a will, then then usually there's no extra step. If there's no will, then there's an extra step if we're talking about the sale of a piece of real estate. So that's the range when the parties aren't getting along.
Right.
We have to file it formally. And what happens is a judge is appointed at that point. When it's informal, there's a magistrate that's appointed. When it's formal, there's a judge appointed. And so if the parties cannot come to an agreement, then there's a trial. And then,
Who knows?
it can stretch on for years and thousands, 10, 20, $30,000, depending on how bad it is, how bad the fighting is.
On a standard probate, gosh, for the term you use for it, informal probate.
Yes.
A family has a property to sell. Maybe an investor finds them, puts them together with you, or a real estate agent brings them together with you. What's the common timeline from the, hey, we have a situation, to the filing, to the sale of the real estate, and then eventually the disposition of the assets?
Usually, if there's a will, okay, usually you're looking at about 2 months. It could be a little faster depending on the speed of the court. If there's no will, then there's an extra step in there, and it might take a bit longer. It might take 3 months or so,
Wow.
just for the court to approve the sale. It's called a license to sell. So the extra step, if there's no will, or if the will doesn't have a power of sale, we call it a power of sale, power to sell real estate inside the will. So it simply says, the executor or the personal representative has the ability to sell real estate. If there's no power of sale in the will, then that extra step is necessary.
And
you could be looking at an extra month there.
And is the court approval of the sale, is that include a process where there's an overbid process, or is that just simply submission of paperwork?
Submission of paperwork.
Mm-hmm.
Yeah.
In California, just to give you a contrast, we have 2 types of sales. With the authority, they can just sell it, and there's a notice of proposed action maybe, and then you wait out. But there are other ones that need court approval. And in that case, the court approval, we have to publicize the sale a certain way. You have to exercise certain activities, and then bring it to the court, and anybody can walk in and overbid on it. But that's California. We're a little more overregulated. So let's talk about the other side. Of course, that same family that might spend $3,000 to do a probate that might be informal without objections and such, what might it cost them to have an appropriate estate plan put together? I know that varies based on the particulars, but kind of think of the same average person who's going to have a informal probate that might cost $3,000. What might that cost for them to avoid the probate had they done an estate plan ahead of time?
So for a simple estate plan, which is the will, the healthcare proxy, and the power of attorney, a typical cost would be it ranges around $1,000 a person. And we do a package for each person because people can select whoever they want to be involved in their estate, in their estate plan. So we do separate packages for everybody. It typically ranges around $1,000 per person to do it. And if there's more drafting involved, trusts and whatnot, then those are separate jobs, and just depends on what needs to be done.
So it sounds like in Massachusetts, you don't really need to have a trust to expedite the probate process. In California, a trust will bypass probate unless there's litigation. But it sounds like in Massachusetts, you don't really need a trust because your system's streamlined enough as long as there's a will that maybe it's not required. Is that a fair statement?
No, actually, so in Massachusetts, it's the same. It's similar to California. Trusts are still effective tools, and we use them. I typically see them in one of 3 realms. Every trust avoids probate, like you say. And so some folks will just come in and they say, I want to do a family trust. I want to avoid probate. I want to make sure my kids get the house without them going to the probate court. So we do what's called an inter vivos trust. Second type of trust that we usually will see is if folks come in, and in Massachusetts, we've got an estate tax. And so if you pass away in Massachusetts and your estate's over $1 million, the state of Massachusetts, they call it Taxachusetts, will tax the estate up to 20%, 15% on the entire estate if it's over $1 million. So we will do trusts in that instance. If I have a married couple, we will do trusts in that instance to either reduce the estate tax or avoid it altogether. And then the third reason why we see trusts, I see trusts in my office is for Medicaid planning.
Right.
And with the Medicaid plan, we do irrevocable trusts. And we usually will structure that, if it's a piece of real estate, we'll structure that irrevocable trust with a life estate. So there's, in my office, there's usually three realms that we see the need for trusts. And they're still an effective tool in Massachusetts. So yeah, while you might have a will, if you hold the asset in your name alone without a joint tenancy or without a beneficiary or without some type of right of survivorship, then it's going to go into probate. It's going to go through your will. And a lot of times people will come in and say, I don't want that, you know? And so that's when the need for trust will come in.
I know another part of your practice is elder law. And a common case that I come across as a real estate agent is, a child will say to me, hey, my dad got talked into buying a property and I don't think he's competent. I had one actually where the hospital, Kaiser, had said they insisted on a conservatorship for his health directives, right? So they're working on a conservatorship for that reason. And then lo and behold, he signs a contract, a very sophisticated contract for real estate for millions of dollars. And the doctor's like, what the heck? He's not competent. What are you doing? And in this case, the buyer kind of got the proposed conservatorship to hire an attorney to fight the conservatorship to say the contract was valid to complete the sale. Unbelievable. And I always tell people that I think the problem there is that one's competence isn't a cut and dry process, right? You don't count. It's not like measuring how tall you are, your weight. No. There's some subjectivity to it. How do you advise, if you would advise me as a real estate agent, I'm dealing with somebody and I'm not sure. Of course, the answer is always be careful and cover yourself. But how would you describe the threshold of competency where maybe one is clearly not competent and or as a real estate agent, I should be concerned and bring it to the right, attention?
So that's a great question. So I know I come across this issue quite a bit in doing estate planning because I have a lot of clients that are up there in age, and many of them do suffer from dementia. And just because they're diagnosed with dementia or they have some issues with memory doesn't mean they're incompetent. There are times when they are lucid. We call it sundown, right? Sometimes in the morning, folks are better than in the afternoon. The brain is like a muscle, right? And so it gets, as you use it, it gets tired. And so during the day, folks will, depending on what their sleep pattern is like, because a lot of times sleep patterns are affected with dementia. As the muscle is used more during the day, they get tired, they get confused more easily. So the long and short of it is I have to sometimes sit with folks and make the determination whether they have the capacity, the ability to sign estate planning documents as well too. And what I usually will do with folks when I meet with them for the first time is I tell the family, listen, you have to bring him in. I don't want him to be, she to be confused when they come in the door. I want them to understand who I am. So you bring them in when you think it's good, and then we will have a conversation. And what I usually will do in the conversation, I make it very relaxed. It's kind of like when I'm talking to you now, Bill. And what I do is I'll talk to them about what they did in the past for a living, what they did today, and what they're planning to do tomorrow. Past, present, and future is what I usually involve in the conversation. I usually look to see if folks recognize their children. That's a big indicator. And a lot of times what happens is these folks is their short-term memory is the first thing to go. But just because their short-term memory is not that good, it doesn't mean they're incompetent. And so if they have the capacity at that point to know who's in front of them, know who they're with, and be able to have a conversation with me about events, then I will note that all down in my file, because that down the line, it could potentially be a challenge. But if they have the capacity to understand what it is that they're talking about and what I'm telling them, then they have the capacity to sign, in my opinion. The other thing that I usually will recommend to families is if, mom or dad is on the verge of dementia or that they're starting to show indications, is to have a letter of competency done by their PCP, the primary care physician, because that will address right away that issue. And, of course, you would want to have that letter of competency very close to the time that they sign their documents as well too.
Right.
So those are things that you might look for. But on your instance, when you're dealing with them as a realtor, my recommendation would be that maybe if there is a family attorney or estate planning attorney involved in the situation, or a probate attorney involved in the situation, that you communicate with them, and have discussions about what this person, and if you're both in agreement as to where this person is, then that's a protector for you.
Right.
And it's protective for the attorney as well, too, to be honest with you,
Right.
to have somebody else as a witness to a person's competency.
The challenge of these cases I find is that often you have that person, senior, who's maybe has moments of lack of clarity, then competency, then lack clarity. A third party catches them. We don't know where they were when they caught them. And there's almost like a shame, like they committed this now. They don't want to change back. They were pressured at that time, but now you're talking to them and that person's not around, but they still feel the pressure of that moment. And it's heartbreaking on one hand. On the other hand, I say to people, that's so difficult to litigate, to prove. How are you going to prove all that? Even if you're true, you don't have a video, you don't have, eyewitnesses on your side. Everybody's going to, say the other side. And I hate to tell people it's not worth pursuing. You're an elder law attorney. What do you say? Obviously, you don't want to talk people out of business, but you also don't want people to take your service and waste their time or money with it either. So how do you advise people when there's those kind of middle of the line issues on elder law and competency, and perhaps a third party that's abusing the situation?
Well, that's what a lot of times what I will do when folks come in the door is I'll make them do a family tree for me, and I'll get to know the family dynamic. I get the individual in front of me, and I'll say to the person that comes in the door, the elderly person that comes in the door, the client, listen, you can talk with me off to the side. You can call me at any time if you want to, or I'll purposely check in with them. And maybe they didn't remember the meeting with me that, the week before. I'll check in with them and see how they feel off to the side, how they feel about the individuals that are involved. Yeah, those are tough cases. I'm in the middle of one right now, conservatorship. There's millions of dollars involved, and I've got two nieces fighting for an aunt. And same type of a situation. It all comes down to what you can prove in a court of law. A lot of times, through witnesses, through letters of competency, if you can get those, through testimony from attorneys, folks that are involved in the cases. Yeah, they're very difficult to prove. This one is a very difficult case to prove as well. It's not an easy, I guess it goes by the scenario, case by case, depending on who's involved, and what you have for professionals involved, how the doctors see it. In this particular case, this person needs round the clock care. At this point, she's progressed with dementia. So, but when I first met her, she was lucid, and she could sign documents. She knew, she recognized people. She could hold a conversation. She could tell you exactly what was going on. Just her short-term memory wasn't there at the time. But they're tough. It's case by case.
Yeah. And so towards that end, if a real estate agent or family has maybe a family member who is having some elder law issues, or if it's just estate planning to avoid all that, or perhaps they're in the midst of it with a probate situation or real estate law, I guess, in general, if they want to get a hold of you, how's the best way do you do consult? Do they send you an email ahead of time? How would somebody ask the questions and get the process started with you?
Let's see. Well, I'm all over social media. So I do have a website. It's ceruololaw.com. The telephone number is there, 781-662-9200. My email is right below there. It's David at Ceruolo Law. You can get in touch with me that way. Like, I'm on Facebook. So I do have Facebook, in LinkedIn, Twitter, and I also have a YouTube channel. I got about 155 videos up there now, informational videos up there as well too. But to get in touch with me, that would be the way to do it. And email's good. As long as I'm here, I usually respond to my my contacts within 24 hours, and we go from there.
Well, that's exactly what I did. Actually, I saw a video you did on your YouTube channel. I can't remember what the topic was. Something to do with estate planning. And from there, clicked, found the website, found the phone number, and here we are. So I just want to tell you, I appreciate you. I'm in Los Angeles. I know you're in Boston, other than being great rivals in sports. But I do have a national platform. I have real estate agents across the country. And if you're a real estate agent and looking for an attorney in real estate or probate, and related to estate planning, and then the elder laws relates to all that. Give David a call, and we gave this the social media. The contacts will be in the description below. David, thank you so much for your time today. I really appreciate it.
No, thank you for having me. I appreciate it. It was nice to meet you face to face.
Likewise. Bye-bye.
All right, take care.